Looks like we're live. Everybody, welcome to the breakdown at MullerSheWrote.com. Thanks for joining us. I'm here today with Adam Klasfeld from All Rise News because we've hit yet another roadblock in the criminal contempt proceedings that are being presided over by Judge Boasberg. About a year ago, almost to the day, he found probable cause that the federal government uh, may have committed criminal contempt by disobeying a court order when he had ordered the planes that were bound for Seacoast Prison to turn around. And, Stephen Miller came on and said, hey, that's just an oral order. It's not written that way. It doesn't count. Oral orders don't count, which is wrong. They absolutely do. And when it first went up to the appeals court, I think it's the same panel, Rao, Walker, and Childs, two Trump appointees and a Biden appointee, voted 2-1 to vacate his finding of probable cause and stop his contempt proceedings. Then what happened is the plaintiffs here, the people who were representing those who were flown to Seacoast, filed what's called an en banc rehearing, and all 11 judges on the D.C. Circuit Court of Appeals reheard. Well, they actually voted 8-3 not to rehear the case en banc, but they voted 6-5 that because the two Trump judges on the panel had differing reasons that weren't overlapping for why they wanted to vacate the contempt proceeding, that it didn't count. It had no practical application. It was moot, basically, which kicked it back down to Judge Boasberg to start all over again. And now here we are again with this 3-judge panel. And their ruling today, I immediately, Adam, I went to Judge Child's dissent and read that first so that I could make sense first of what the majority did, the 2 Trump judges did, and like the reality of the situation. Talk a little bit about it's a 122-page, she had an 80-page dissent, Judge Childs. And it was pretty straightforward and scathing. Talk a little bit about, I guess my first question is, are at least the 2 Trump judges in agreement this time for why they're vacating this contempt proceeding?
Pretty much, Allison. What the reasoning that I saw, now there was a concurring opinion where Judge Walker gave a different kind of explanation for why the court was doing what it was doing, but it did, the basic agreement between the 2 Trump appointees is that this isn't about the contempt power writ large. This is, as they would have it, over the facts of this case, and they interpret the facts of this case, as you said it just now, that they accepted the DOJ's explanation that there was an oral order and then a written order. And when the written order came out, they argue, it superseded the oral order, and that the written order differed from the oral order in certain ways. Now, that's how they put it. I'm going to read from Judge Childs' dissent, because what she is effectively saying is that this is a blow to the rule of law, and that without contempt of court as a possible punishment, the rule of law itself is an illusion. Here's what.
And before you read her quote, I just want to let everybody know what this 2-judge majority did today was issue, I believe, a writ of mandamus, which is a very unusual remedy. It's a really high bar, and so I just wanted to
it's an incredible rebuke, and the first one was a writ of mandamus as well. So these are 2 writs of mandamus. It's an extraordinary remedy, and so this is going to be grist for the mill of the Trump administration's attacks on Judge Boasberg. They've tried to file a disciplinary complaint against him. They've tried to gin up impeachment proceedings against him. This will be used in that manner, and I'll go back to why the actual details of the ruling don't fit that narrative. But first, this is the dissent. Contempt of court is a public offense, and the fate of our democratic republic will depend on whether we treat it as such. In many forms in which it can be committed, contempt degrades the power of the people through their Constitution and Congress gave federal courts. Without the contempt power, the rule of law is an illusion, a theory that stands upon shifting sands. So that, I think, really got to the core of the entire stakes of this battle. Because let's go back to what we're talking about, the March 2025 deportation flights, when the Trump administration hustled hundreds of Venezuelan immigrants onto airplanes without due process. As you said, federal Judge Boasberg, ordered them to turn the planes around. And there was a second part of the order that, if those planes are on Salvadoran soil, do not turn them over to Salvadoran authority. And then he issued the written order. This is just to give the government's point of view here. Here's how they argue it, and here's what the majority accepted. The government argues that when the written order came out, it didn't explicitly say, don't hand these out to Bukele, these people out to Bukele and Sika to be put in a foreign dungeon. Although it memorialized in broad strokes what Boasberg said from the bench. So the Trump appointees on this panel say, aha, they were to believe that this was a superseding order, and that the government was trying in good faith to follow the order, that when the oral order was binding, they didn't transfer these immigrants. When the written order was issued, then they handed over the immigrants. But taking that interpretation forces us to forget everything that happened in the interregnum. We remember the whistleblower report. Remember when it came out, and this was going to come, absent this ruling, we would have had contempt proceedings in federal court before Boasberg, where that whistleblower who said that former Justice Department official, now federal judge Emil Bovey, told members of the Justice Department that they may have to tell judges F you. We would have heard testimony about this. This order blocks that testimony, and it accepts at that the contention from the government that, there was some lack of clarity of what happened between the oral order and the written order. And here's what Judge Child says about that, because I think it's so important. Now, any litigant can argue, based on their preferred interpretation of a court's order, that they did not commit contempt before contempt findings are even made. And now, any challenge where one may wave the wand of separation of powers, the government knows that it can petition this court for mandamus to relieve it from such proceedings. I cannot agree to an approach that sets that precedent. So, and just one more point I want to make about that, that it's important to emphasize how constrained Judge Boasberg's ruling was. His ruling was, we are going to have contempt proceedings. I'm going to hear from the whistleblower, who we heard from before Bove was elevated to the Third Circuit Court of Appeals. We're going to find out what happened. The D.C. Circuit says, no, you can't do that. That itself, what Judge Rao calls a freewheeling inquiry, is beyond the court's power. So they're restraining the judge not only to the point of issuing a probable cause finding of criminal contempt. They're saying you can't look into it. You cannot hold hearings. And they are justifying it on the fact-specific thing. They're saying, this isn't a threat to the rule of law. This isn't a threat to judges' contempt powers. This is an application, this is a read of these facts, barring any kind of fact-finding that the public knows, but the court will never hear. We all know, if we've been following the news about this case, any news about this case since March 2025, that there was a whistleblower. The whistleblower said that Trump's former attorney turned Third Circuit Judge Emil Bove, in his short time in the Justice Department, said, you're going to have to tell the judges F you, something that any of us can easily recognize as contempt of court. You have the DC Circuit, two of the most conservative judges, Trump appointees, saying, no, you can't even start this inquiry because the government has this theory and we accept that theory. So they're framing it in the language and the logic of this ruling as something really contained, fact specific, and that everyone who's calling this a threat to the rule of law has it all wrong. But if you look at just what is being blocked here, if you look at the fact that Trump and the DOJ have been vilifying Judge Boasberg, and this is going to supercharge it because, as you said, Allison, that that a writ of mandamus is an extraordinary ruling. That this has happened twice to a federal judge is going to be used to vilify him further. A respected judge who has been appointed first to the bench by George W. Bush, then by when he was elevated to a federal court because of DC's jurisdiction, then by Barack Obama, sat on the Foreign Intelligence Surveillance Court, handpicked by Chief Justice Roberts, bipartisan bona fides. This ruling is going to be used to vilify him as some sort of partisan actor who has been slapped down twice in one of the most kind of extraordinary methods for slapping a judge down.
Right. And Judge Childs brings that up too, the things that you have to meet to issue a writ of mandamus and how we have changed the idea of the writ since the revolution, right? And she goes into the history of it. And she says, I find nothing in the petition before us to warrant the use of mandamus, especially at this interlocutory stage. The government has failed to show that it has no other form of relief available to it. The government has not shown that it has a clear and indisputable right to relief under controlling law, despite advancing several theories, nor has the government shown that mandamus is the appropriate relief for this court to provide under the circumstances before us. As a result, we should not grant a petition for a writ of mandamus here, and yet the majority has done so. And here's some really interesting language she says about the history of mandamus. She says, however, crossing the midnight blue of the Atlantic and then shrugging off the yokes of the king changed both the source and the scope of the judicial power to issue the writ. These changes involve more than converting the prerogative writs into injunctive orders provided by a statute or implied by the same. And then she cites a case from 1838 called Kendall v. United States, saying mandamus is not exercised as in England by the king's bench as having a general supervising power over inferior courts. And so her whole point for several pages was like, look, you can't take away the inherent power of a district court to find facts
Right. And that
before it even happens. That's what she means by at this interlocutory stage. And so I imagine, and I think you probably agree, that the plaintiffs here will probably ask for another rehearing en banc.
Right. I've reached out to the ACLU to find out if they're going to do just that. I haven't heard that yet. I have heard their statement that they call this a threat to the rule of law. And so they have done it before. They may try to do this again. There is the case, the underlying case that is still under appeal itself. You had Boasberg issue a ruling that yes, even though the men were whisked out of the country without due process, doesn't mean that there's no remedy for them now. Doesn't mean that they aren't entitled to some sort of after the fact due process, either being brought to the United States for proceedings or over in Venezuela. That is under appeal. The case goes forward. So I'm going to be looking to see what the ACLU has to say about this. My thinking about where Judge Walker's concurrence is, it's really interesting to me because in both of these rulings, where Judge Walker, one of the Trump appointees in the majority, gave in both of his orders, he seems to be sympathetic for Judge Boasberg. And that's an important nuance because, again, this is going to be used to vilify Boasberg. He says this is a complicated case. It's a statute that's been used 3 times in U.S. history. It's from the 1700s. This is the first time it's been used in more than 70 years after World War II. And so he says that Judge Boasberg is a dispassionate jurist with a very respected record, and he just happened to have gotten this wrong. I think where Walker is, how he sees this, is that he did not see the criminal contempt inquiry going to any place where other than a clash between the branches, by which I mean, let's say Judge Boasberg referred it to the Justice Department. Well, the Trump Justice Department isn't taking the case. There was another possibility that Judge Boasberg raised of having private prosecutors prosecute criminal contempt. And Judge Walker's reaction to that in the first ruling was, well, that private prosecutor, for constitutional reasons, would also report to the Attorney General of the United States. So, what this reads to me is Judge Walker wants an off ramp, that he is sympathetic to Judge Boasberg much more than I see Judge Rao here. And he's looking for an off ramp. But I think what Judge Childs is saying in the dissent is, this off ramp threatens the contempt power itself. And without the contempt power, law is an illusion because there aren't any consequences. So this will go through the political machine. I think that MAGA World is going to try to attack Judge Boasberg on this. They should know that one of the 2 judges who mandamused Boasberg on this particular case also expressed respect, admiration for him, said he's in a difficult spot. This isn't. This is certainly a rebuke. 2 writs of mandamus are a rebuke, but the background and the full context of this show that this has been brinksmanship by the DOJ, and this round brinksmanship work for the DOJ. There won't be that whistleblower testimony. They won't have to hear about what Bovey said privately about listening to or defying a judge's orders before sending hundreds of men to El Salvador without due process.
Well, not yet. Anyway, not yet. Because I think what Judge Childs is saying is that we need to preserve the rule of law and contempt power in the district court by allowing this. Sorry, Judge Walker, we have to allow it to take its course. We can't take this off ramp. And as much as you might think that you see the end coming, doing this now puts the inherent contempt power in jeopardy. And so we can't do it this way. And I would assume that if the ACLU is going to file for a rehearing en banc, that might also be their argument.
Right. So, and this, as we've read passages from this dissent. It's a very passionate dissent that could inspire, theoretically, some of the judges from the DC Circuit bench to ask for en banc. It's been known to happen. It happened during.
Did the first en banc, was that sua sponte, or was there did ACLU ask for a rehearing?
I can't recall offhand, but I know that sua sponte is how it happened in the case of, I'm sure folks remember, the National Guard on the streets of Los Angeles, that it's been known to happen. Sometimes the appellate court says, hey, this panel got it wrong. Let's all take a crack at this. We'll see how it happens, but that this is the latest.
Yeah. Well, thanks for keeping your eye on it for us. Everybody, you can follow more and get more detail at All Rise News. And I appreciate you answering some of these questions that I had today about this about the second block of contempt proceedings by Judge Boasberg. Adam Klasfeld, thank you so very much.
Thank you very much, Allison. Always a pleasure talking.
It's always great to talk to you. And everybody, if you have the ability, all the stuff's free at All Rise News, but if you have the ability and the means to financially support Adam, it really helps when he travels. As I've said multiple times, he doesn't have any corporate overlords to pay for his travel expenses. He does it all himself. So if you can support, please do. And thanks for being here. I got to jump off. I got to go talk to Colonel Chris Carmichael about what's going on with the Iran war and the blockade of the blockade. So I do appreciate everybody being here today. Thanks.
Thank you.